Okay, so we're going to talk about how the COVID-19 is affecting non-immigrant workers in businesses, or how it's affecting businesses that are hired, that hire non-immigrant workers. This webinar is prepared, the content is prepared by Attorney Don Nguyen and attorney in our firm, as well as myself. So Don Nguyen is not available this afternoon, so I'm going to be the only speaker today. Okay, so just quickly information about the two people that prepared this talk. So Attorney Don Nguyen, he has law license in the state of Iowa as well as in a couple other states. Okay, I myself have a PhD degree, and I was a professor at university. And so we have three offices in Des Moines, Coralville, and Minneapolis. So if anybody have any questions or need our service, so please call us at 515-288-3188. All right, a quick disclaimer. So this webinar is a free service to help our business clients to cope with the pandemic. So we have a series of free webinars to our business clients, and also they're of course they're also open to the general public. So that's open to other business owners as well. And so our webinar is to how help business owners to cope with all kinds of problems that's being caused by the COVID-19 pandemic. And our webinars are for general information only, and of course that applies to this one as well. So it's for general information only, and we're not responsible for any damages that you may suffer as a result of relying on any of the information or advice provided herein. So please consult your own legal counsel if you need legal service, or you can consult our firm's attorney. As I mentioned, we do have a licensed attorney in our firm. So again, our number is 515-288-3188, and there's also a cell phone number for that service, 515-559-7378. All right, so before we talk about how the non-immigrant workers or businesses that hire non-immigrant workers are affected by a pandemic, so let's quickly review or recall the common types of work authorizations. So for most business owners, you are familiar with the I-9 form, because the I-9, as I indicate at the bottom of the screen, so I-9 is required for and then all employees. So when whichever business, whenever you hire a new employee, you are required to fill up I-9, and even if the employee, the person you're employing, is a U.S. citizen, okay, you're still required to do a I-9. All right, the common types of work authorization that meet I-9 requirements. So I listed several here. Okay, so of course, if the employee is a U.S. citizen, there's no issue with that, or a lawful permanent resident, or commonly called a green card holders. So of course, these are also free to work. And also there are several types of work visas, and they really should be called in work authorization, or it's a status to work. But they're commonly called work visas. Let's just use that term. Those there are several types I listed here, such as H-1B, L-1A, and TN. Of course, there are several other types of work visas, and those work visas typically they are employer specific. In other words, they are only allowed to work for the specific employer. If you want to change to a different employer, and they have to get a new work visa in order to work for the new employer. Okay, and that really, I mean, again, so you need to get a new work authorization, perhaps the same type, but still it's going to be a new work authorization. All right, and then there are also those EAD cards. So the EAD They come in a little card, just like a green card, but it's called different. It's called Employment Authorization Document. For short, it's EAD, and so EAD card. And there are many different kinds of EAD cards, and typically these are open work authorizations. In other words, they are not employer specific. And so that includes student OPT, if a student received a degree, bachelor's degree or master's degree, and so that the student will have at least 1 year of OPT work authorization. And then, or if you have a green card application pending, or if you are you are here as a visitor or whatever status you are here legally, and you are here, and then your country runs into a turmoil, and so then the U.S. might have issued a temporary protective status for citizens of that country that are in the U.S. So if you may be in a TPS situation, or a lot of people probably know about it, DACA. And so many of our Mexican friends are in that situation in a DACA, so they might have DACA approval, and then they may have a EAD based on DACA. And then, so there are also some H4. So H4 are dependent of H1. So some of those H4 dependents, they may be eligible to get a EAD card. And L2 are dependent of L1 visa holders, and so some of those L2, well, actually to be precise, the spouses of L1, if that spouse is on L2, and that's also eligible to get a EAD card. And those EAD cards typically, as I mentioned earlier, are non-employer specific. They are open work authorization. They can work for anybody, change from one employer to another without problems. Okay, so that's the common types of work authorizations. That's a quick overview of that. And then a lot of businesses, in fact, everybody is affected by the pandemic one way or another. And so most businesses, in fact, probably it's safe to say all businesses are affected by the pandemic one way or another. And so all businesses are coping with the pandemics in different ways. So I listed a few different. I listed 4 examples. Such as so your business may be fully open, and such as a supermarket or other essential businesses. Or if you're a tech company, and so the supermarket and tech companies, in fact, they are booming during the pandemic instead of suffering. Okay, or if you are able to let all of your employees work from home, many big tech companies are doing that, such as Facebook, Amazon, and Google, such as the big tech giants. Many of their workers are working from home, or if you're a small business, you have to temporarily close your business, whether and by your choice due to the risks involved with the virus, or it's ordered by the government to shut down temporarily. Okay, so then if your business is closed, then you may have to lay off your workers or at least furlough your employees. Okay, or you may be able to keep your business partially open, but you have to reduce employee hours, or perhaps even reduce their hourly wages and all that. And so, in order to, because of the reduced hours or reduced requirements for your business. Okay, and there are other ways. Business owners are getting creative in dealing with the pandemic. There may be other ones. So I think these 4 are the 4 common types, I would say, that I want to cover in this webinar here. And then we'll see how in each situation and each type of those work authorizations will be affected. All right. U.S. citizens and lawful permanent residents obviously, these two types of work authorizations are not affected. I mean, a U.S. citizen, this is a free country, and U.S. citizens or even green card holders, they are free to go anywhere and work for anybody, or not to work at all. And so you have the choice you have the freedom to decide what you do. But for those people that are on visas, on non-immigrant visas, they will have to deal with their status situation. Okay, so first of all, let me cover the people who are on employment authorization document, or that EAD card I mentioned earlier. And as I mentioned earlier, EAD cards, these are open work authorizations, so they are not bound to a specific employer, so they can go to work for anybody, or not to work at all in many cases, okay, or in most cases even. And so the validity of EAD card is not affected in general by layoffs or business closures or furlough or reduction in hours and things like that. So they are not required, and they are not affected in general. And also EAD holders, they may choose to work, but they actually are not required to work in most cases. All right, there's only one exception about that, whether they are required to work or not. That's the student OPT EAD card. If a foreign student just finished a degree and have a optional practical training EAD card, and so that student is free to choose an employer, okay, and you can change employment. There's no issue with that, but you are not allowed to have a 90-day gap in employment. So if you stay at home here in the U.S. and not working for more than 90 days, then your EAD card is considered terminated. Okay, so then you're going to be in trouble, even if you rigorous speaking, and you're going to be in some kind of problem situation, and even you find an employer after the 90 days. Okay. All right, and so for those employees that are on H-1B, so depending on how your business is dealing with the pandemic, so the H-1B may be affected in different ways. So first of all, obviously, if your business is fully open, and such as the supermarket and the tech companies that I was talking about earlier as an example. So if the business is not affected by the pandemic, and your business is running as usual, and so then, of course, all your employees are still paid the same. They are working the same hours and paid the same. And so then the validity of H-1B is not affected. Okay, so the mere fact that we have a pandemic does not invalidate an H-1B visas, or actually any other visas. Okay, so it's only how when your business is affected in some way, then those workers, visa workers, may be affected. Okay. All right. So if you are in your business send all employees home to work from home, and they're actually the home is considered a work location in that situation. Okay. So for example, if you have just one facility, one office facility. So before the pandemic, you have one office, one work location, and if you have 50 workers, now you send everybody home, and so all of a sudden you have 51 work locations because each employee's home is considered a work location for your business. And for H-1B, there is a requirement to do a labor certification posting. Okay, so the DOL did relax the requirement a little bit. So it used to be the posting has to be done prior to the person start to work at that new location, but now that can be done within 30 days after the commencement of the employment at the new location. Okay, but that still need to be done. Okay, the LCA posting still need to be done. That actually can be done at the home. All right, and of course, this only need to be done for those H1 workers. So if you have 50 employees, 49 of them are U.S. citizen or green card holders. There's only one H1 worker, and only that one H1 worker. So that you need to do a LCA posting, but you don't have to do that for all the other 49 and U.S. citizen or permanent resident workers. And if your employee is in a different location, like, for example, if the employee decided that you allow them to work from home, but then he decided that his parents are in a different state, maybe have a ranch or a farm somewhere, and he thinks it's pretty safe to work there, or safer to work there than to work in a city. So he may go there, but then in that situation, it's possible a new labor certification application is required, and then amendment to the H1 work authorization may be needed in that situation. And if your business is temporarily closed, meaning that you have to lay off some people, and then if that H1 worker is laid off, then his work authorization may be invalidated. Okay, so maybe not right away, because I had to mention at the very bottom. So there is a 60-day grace period for the H1 worker to be still considered in status, and so but beyond the 60 days, that person would the H1B would be completely invalidated. Okay, and so if your business is partially open, so you have to reduce the employees' hours, and then again, because the H1B work authorization comes with the specific employment terms, and so when the USCIS grant and the approval of the H1B work authorization, so that approval is based on those specific employment terms that include the number of hours and the salary. And so if you reduce either the hours or salary wages, so then that's considered a violation of the H1B terms, so that H1B may be invalidated. Okay, but again, so there is a 60-day grace period, so that the employee is laid off may seek new employment. But if he does find a new employer, and a new H1B petition is required because H1B is employer specific. Right, and so by the way, for those who, this presentation makes sense only for those who are already familiar with H1B visas. I just quickly mentioned that H1B is a work visa for basically degreed professionals. There's also this the TN work visa, and that's a North American free trade visa, basically. So that's for Canadian citizens and the Mexican citizens that are employed in the U.S. And then, of course, this is also a professional visa. So there's a specific list of professions that are eligible for those TN visas. Okay, and of course, the applicant or the employee must be either a Canadian citizen or Mexican citizen, and also the profession of the employment, of the underlying employment, must be on the TN list. All right, so it's actually almost redundant. So, if a business is fully open, and then the visa obviously is not affected because all the workers are they're still employed for the same hours and same wage. And so, of course, there's no violation of terms of employment for TN, and so then that they're not affected. Okay, and if the employee, if you send them to work from home, TN does not have or does not come with the labor certification requirement, so TN is not required, unlike H1, so where the posting may be needed. So TN actually, just like your business is fully open, so for TN you probably don't have to do anything. Then if your business is temporarily closed, so you have to lay off the employees, and again, that will be a violation. So if a TN worker is terminated, is laid off, and so then is not making salary, it doesn't have any work hours, so that's a violation of the TN terms, and so that TN may be invalidated. Okay, and so if your business is partially open, but you have to reduce hours and or wages for your workers, and especially TN workers, then the TN workers' work visa may be invalidated in that situation. And just like H1, so there is a 60-day grace period, and if the TN worker does find a new employment, so he's free to go to the new employment if that new employment is also on the TN list of professions, but a new petition by the new employer is required. Okay, so because TN is employer specific, just like H1 is. Also, there's the L1A work visa. So L1A is for multinational or actually intercompany transferees. So if a company has a branch in the U.S. Maybe the U.S. company has a branch in another country, and then you are bringing a manager from the office in the foreign country to the U.S. office, okay, and so then you can bring such a foreign worker on a L1A visa, and so if your business is not affected by COVID-19, so then of course the L1A workers, their employment is not affected, so their validity of visa is not affected at all. And if you allow all of your employees, including L1A workers, to work from home, and because L1A does not come with a LCA posting requirement, so L1A is not affected in that sense. And if your business is closed, and the L1A, basically when you laid off all of your employees, so then L1A may be invalidated in that situation. Okay, I actually should say it is invalidated, but because of the 60-day grace period, and so by putting this may be invalidated in all of my transparencies here, but in fact, in that situation, it is invalidated if you go beyond the 60-day grace period. Right, and if your business is partially open, and then you had to reduce employee hours and or wages, and then again, so that will constitute a violation of the employment terms on which the L1A was approved. And so because of violations, so the L1A is invalidated. Okay, and so just like H1 and TN, so there is also a 60-day grace period for L1A, but unlike H1A and H1B and TN, for L1A it will be very hard to change to a new employer because L1A is for intercompany transferees. So if unless this company has 2 U.S. offices, and then one is closed or temporarily closed, and you kept the other one open, and the employer is sending this L1A employee, or should say an L1A manager, to the other office on the management position. So if that's a situation, so maybe a new petition can be filed, but in most cases, So it's going to actually going to be very hard to do a new petition in the L1A situation. All right, so that's how the common types of work authorizations are affected if your business is affected by the COVID-19 in one way or another. All right, and some general tips for both the employer and employee that and if it, for the visa employees, of course, but also for employers that hire foreign employees. Okay, you may be thinking sending. Due to the nature of your business, you may need to send your employees to overseas on a business trip. So if that's a situation or that's the case, you really should think about not to send foreign employees out of the country because there are those a lot of travel restrictions imposed by different countries, by airlines, and even at the foreign employee's home country. And so that home country, that including even Canada, for instance. Okay, so because Canada, there is a quarantine requirement. So if you send a Canadian TN worker on a business trip to Canada, so that employee will be required to quarantine him or herself in Canada for 14 days before he's allowed to go out and perform his duties. And if he's confined in a hotel and do all the jobs, but might as well just have him do the job here in the U.S. instead of sending him or her to Canada in that situation. Okay, so basically, travel for foreign employees is strongly discouraged. And if you do have to travel, so make sure you have the visas to go through not only your destination points, but also all the transiting points. You need to find out the requirements. For example, if one place you have to quarantine for 14 days in one of the transiting points, and that the 14 days is no longer a transit, it's no longer considered transit, you may have to have a valid visa to go through that point. Okay, so these are some things you have to be really careful. Okay, and also for foreign employees to come back to the U.S. can be very problematic, as if they don't have a valid visa right now, and if they go out, and they may not be able to get a new visa until after the end of the year, and even that we're not sure. So the presidential proclamation and banned the issuance of new visas through the end of the year, so that may be expanded. That ban may be extended, so depending on what the situation will be. All right, and then for those foreign employees that the validity of their work visa is affected, and so if they are having problem returning to their country safely at this time, and so they may consider to apply for change of status to stay in the U.S. legally. So many of them will be eligible to apply for B2 status. Okay, so that will be a viable option for most non-immigrant. Okay, so let me also quickly mention that so there are also immigrant visa. There are some different employment-based immigrant visa categories. So from EB1, EB means employment-based, EB1 all the way through EB5. Okay, and so most of these immigrant applications, because they do require processing time as well as waiting for the priority date to become current. Okay, so then in the interim, maintenance status is required. So that really, we can't get away from the previous points we discussed. How to make sure that their work visas are still valid. Okay, and for some of those visas, if the priority date is current, they actually may be able to file the immigrant visa plus the green card application together right away. So if the priority date is current, so that may or may not be an option depending on from which country you were born.